now in session.
Thank you. Please be seated. This is Arizona Court of Appeals, cause number CACV120315, Cobalt versus Aetna Life Insurance Company. For the party's information, these proceedings are being recorded both audially and visually. Hopefully, if everything works well, you will have your 20 minutes of fame on YouTube. Please identify yourself as you approach the podium and let us know who you are representing. Each side will have 20 minutes, and we understand that amicus will have 7 minutes of appellant's time. Is that correct? Okay.
That's correct, Your Honor.
The clock on the podium will tell you how much time you have. And so if you including any rebuttal time. So if it says you've got 10 minutes and you want 5 minutes of rebuttal, that 10 minutes includes your 5 minutes of rebuttal. And if you'll tell us if you want rebuttal and how much time you want, we'll try not to horn in too much on your time. We have read the briefs, looked at the record, and discussed the case in conference this morning. So with that in mind, you may begin.
Thank you, and good morning, Your Honor. And may it please the Court. Jonathan Bond for Appellant Aetna Life Insurance Company. With the Court's permission, I'd like to reserve 4 of my 13 minutes for rebuttal. This case is back on remand from the U.S. Supreme Court because the legal landscape in this case has significantly changed since this Court's prior decision. When this Court issued its prior opinion, it did not have before it any regulation from a federal agency addressing whether the Federal Employees Health Benefits Act, or FEBA, preempts Arizona's anti-reimbursement doctrine. But what the Court found missing has since been supplied. OPM has now adopted, after notice and comment, a binding federal regulation that speaks directly to that issue. So the question before the Court is now very different. As Mr. Cobalt agrees, the only issue before you is whether OPM's interpretation in its regulation is reasonable. If it does, or if it is, then it controls under Chevron. And that regulation is reasonable as a construction of the statutory text and Congress's purposes. Mr. Cobalt has not carried his burden of demonstrating that OPM's interpretation, which many other courts also have adopted, is unreasonable. For these reasons, the Superior Court's judgment should be reversed. Now first, the Chevron framework applies to this case, and that's common ground, and it's very important because it means that OPM's reading need only be reasonable. We submit that it is at least reasonable as a matter of construing the statutory text and Congress's purposes. Now turning first to the text, OPM reasonably determined that reimbursement provisions relate at a minimum to payments with respect to benefits. Now, that language isn't parsed in this Court's prior opinion, but it strongly supports OPM's regulation. The whole point of a reimbursement provision is to undo or reduce a prior payment with respect to benefits.
The Supreme Court used the word plausible. Is it your contention that reasonable in this context is really the same as permissible?
Your Honor, in this context, yes, and this issue didn't come up in the briefing, but the Supreme Court has said exactly that. In a case called Rust v. Sullivan, 500 U.S. 173, the Court said that Chevron deference applies, and the Court there applied Chevron deference, so long as the agency's interpretation is plausible and not otherwise contradicted by the statutory scheme. So here, the agency's interpretation is plausible, and whatever what reasonableness means, the agency's interpretation here is reasonable, both in terms of the context and the text of the statute and the purposes.
So as long as the agency interpretation passes the laugh test and doesn't directly offend the provisions of a congressional enactment, judicial interpretation is foreclosed. That's your position.
It's not the laugh test, Your Honor. It's a plausible reading of the text and a reasonable policy choice for the agency to make. And we submit that OPM's interpretation is at least reasonable with respect to the text and reflects a reasonable policy choice, because Congress made clear in the legislative history of the original preemption provision and the 1998 provisions that expanded it in 2 significant respects the purposes it was trying to achieve. Congress was looking both to preserve uniformity and maximize uniformity in the legal rules that apply to these contracts, and also to to minimize the cost of the program, because the ones who ultimately pay for this are FEBA participants and taxpayers.
You don't want courts, though, considering whether a policy choice of a federal agency is reasonable, do you? I mean, that's not our business.
Your Honor, the court's task is to determine whether the agency's policy choice is at least reasonable. That doesn't mean the court should determine whether it's the most reasonable or the most persuasive. It just needs to meet that minimum standard of reasonableness. And here there's not really any dispute about Congress's purposes in enacting this statute. The legislative history is quite clear, both in the original 1978 statute and in the later statute, where Congress broadened it, both by providing that not just provisions that relate to the nature and extent of benefits, but also contract provisions that relate to the provision of benefits and benefit payments, and also by removing the requirement that state laws must be inconsistent with a contract to apply. So Congress has made those purposes clear, and OPM reasonably determined that these reimbursement rights relate directly to those purposes and further those purposes. And there's really no contrary argument on the other side as to how allowing these provisions to operate would advance Congress's aims. So in addition to those purposes, the text we submit strongly supports OPM's reading, at least as a plausible reading of the text, because not only with payments with respect to benefits, but even the provision of benefits themselves, and that's for at least two reasons. First, the net entitlement that the participant has to receive value from his plan depends directly on the reimbursement provision. So here the carrier provided value, provided medical services, in this instance by paying a medical provider, in other cases by making a payment directly to the participant. But whether or not he is able to retain that depends on the term of this contract, depends on the reimbursement provision. But even beyond what he specifically was permitted to retain, reimbursement provisions affect the provision of benefits for participants more generally. The statute requires, and this is section 8902 subsection I, that the rates charged must reflect reasonably and equitably the cost of providing benefits. A reimbursement provision in a contract directly affects that, because if the carrier is allowed and indeed required under its contract with OPM to seek reimbursement, then the cost that it pays to provide benefits for a pool of participants is significantly lower. So if a carrier knows...
Doesn't necessarily mean it's equitable, right? I mean, in fact, one could argue that federal employees under this regulation have fewer rights under state law than non-federal employees. And so when you say that cheaper necessarily equates to equitable, is that a sustainable position?
So, Your Honor, to be clear, our point is not that cheaper is more equitable, simply that when FEBA carriers and OPM set rates for plans going forward, those rates, the statute requires, must equitably and reasonably reflect the actual cost. Our point is simply that when they set those rates, they must reflect the realities. But in fact, with respect to private employees, that's an important point, because in the private context, the U.S. Supreme Court has said that reimbursement rights do relate to benefits, and therefore state laws in that context are preempted. The court held that in FMC versus Holliday. And whatever differences one might perceive at the margin between these two statutes, it doesn't make sense to assume that Congress wanted less uniformity and more state law interference for federal employees that it employs than for private employees who are ordinarily subject to state law. So we think that uniformity interest is even greater in this context. So as we say, the important point with respect to benefits is both that the benefits that the individual retains depend on this reimbursement provision, and the benefits that everyone gets going forward depend on the calculations that the carrier and OPM must make, which take account of the reimbursement provision. If the carrier knows that each year it'll be able to recoup 10% of recoveries because participants are able to get from the party who actually injured them the compensation for those injuries, then the carriers and OPM will adjust their rates and adjust everyone else's benefits, or really what they pay for those benefits, accordingly. So for both reasons, it affects the benefits in addition to payments with respect to benefits. So as an interpretation of the text and of Congress's purposes, it's at least a reasonable construction. We contend that that's dispositive under Chevron. And finally, just before reserving time for rebuttal, I'd like to briefly touch on one of the arguments that Mr. Kobold makes, that the presumption against preemption requires a different result here. That's not true and is in fact specifically foreclosed by U.S. Supreme Court precedent. In the Smiley case, the court held that the presumption does not trump Chevron. It works the other way around. And that's because in Chevron, the whole point is that Congress intends ambiguities in a statute to be resolved in the first instance by an agency, So when it comes to a question of the scope of preemption, that was the issue in Smiley, and it's the issue here. The ambiguity or the scope of that provision is to be determined by the agency. As long as it is reasonable, it controls, notwithstanding the contrary view of any court.
Before you run out of time, do you want to address the appellee's argument that this is a matter really of contract and it extends preemption too far to have a contract provision preempt state law?
Certainly, Your Honor. A few quick points on that. The contract is not achieving the preemption here. It's the statute. That's how the Second Circuit read it, and that's how OPM reads it. It's the statute that declares state law preempted. It simply ties the scope of that preemption to contracts. There's nothing remarkable about that. A number of statutes do exactly that. The Federal Arbitration Act, for instance. But even if you thought that raised a constitutional question, Mr. Kobold's reading does not avoid any constitutional problem. It actually creates one. That reading that OPM and the Second Circuit have adopted avoids any constitutional problem. But his reading does not allow you to solve that because it's clear on the face of the statute that the terms of contracts govern the scope of preemption. So if you conclude there's a constitutional question, his reading doesn't let you avoid it. You would have to address that head on if he had not waived it. But he waived that argument by raising it neither in the courts below nor even in this court. He even says now only probably that it's unconstitutional, not that it is. So that argument, we suggest, is not properly before you. So for all of these reasons, we urge you to reverse the court below. With the court's permission, I'd like to reserve my time for rebuttal.
Thank you.
Thank you.
Good morning. I'm Henry Whitaker from the Department of Justice, appearing on behalf of the United States. I'd like to just emphasize the distinctive federal interests that are in play here. This case involves the provision of benefits to federal employees by federal health insurance carriers under contracts negotiated by a federal agency with that carrier under the Federal Employee Health.
I don't think there's any dispute that there's a strong federal nexus here.
Yes, Your Honor, but I think it bears emphasizing because the federal government is responsible for tens of billions of dollars of premiums under this program, and the subrogation and reimbursement rights in federal carrier contracts, importantly, bear on that because, as the Office of Personnel Management explained in the regulation, those costs have a direct relationship to the amounts that the federal government is on the hook for this program. And that's true not only in this case, which involves a community-rated carrier, but perhaps more directly in experience-rated carriers, where the money recovered from these funds actually goes directly to the federal government. And indeed, as OPM noted in its rule in interpreting this statute to apply it to subrogation and reimbursement rights, Congress in the legislative history specifically noted this kind of interest as one of the principal reasons for the preemption provision. And that's true not just when Congress expanded preemption in the 90s, but indeed when Congress initially enacted the statute in 1978. One of the principal targets of the preemption provision as it was originally enacted were state-mandated benefit laws, basically when states would say you have to provide certain kinds of benefits. And what Congress said is, well, no, we think that the federal contract should govern the particular kinds of benefits that are being provided. And something very similar, although not identical, is going on with regard to subrogation and reimbursement recoveries, because I think, as Mr. Bond quite ably underscored to you in the opening, there is a direct one-to-one correlation between benefits and payments with respect to benefits that are paid, and the statute does apply to both, contract terms that relate to payments or payments with respect to benefits, and the reimbursement right. And that connection is quite clearly made by the contract in this case, which ties the amount of the reimbursement right directly to the amount of benefits previously paid. So at a minimum, there is some relation. It's a right to reimbursement of benefits is not unrelated to benefits.
I think the Supreme Court has already acknowledged that there are two plausible interpretations here.
Yeah, I think that's significant. And Your Honor asked about whether there's any daylight between the term plausible and reasonable, and it's difficult for me to understand how there is very much, if any. I mean, and that, you know, there were some dictionary definitions, I believe, of that term cited by the other side, and I think that one of the definitions he didn't cite is one thing plausible a lot of times means is appearing worthy of belief, not just passing the laugh test, but you know, I think the Supreme Court did engage in real interpretation in McVeigh, and indeed this court, the last time this case was here, noted that, you know, the McVeigh did say that there were different interpretations of the statute.
And it's an interesting reality, though, don't you think, that the agency is free to change its mind. The agency could, under some future administration, decide to adopt the contrary interpretation as also reasonable. Yes? I mean, isn't that what the Supreme Court has expressly held?
Potentially, Your Honor, and Your Honor makes a good point. Not just when the agency changes, but also, as the Supreme Court recognized in the Brand X case, even when a court has previously opined on a question, and indeed in Brand X was reviewing a Ninth Circuit decision that had said that the quote the most reasonable interpretation of the statute went one way, and the Supreme Court said, well, and the agency came to a different conclusion. And the Supreme Court said in Brand X, the agency is entitled to do that. And
whereas courts are generally charged with dispassionate interpretation of text without the influence of policy views, agencies are not. We compete for the same turf.
Within the bounds of reasonable interpretation, and that's really a product of the Supreme Court's analysis in the Chevron case, which rests on the premise that, yes, with regard to statutory ambiguities where there's room for reasonable interpretation, the agency's policy expertise should kick in, and that's exactly what has happened here.
Is that truly an interpretation then? If the law is going to yield to the agency's policy views, is the agency truly interpreting a statute, or is it engaged in something more substantive?
Well, I think in a sense it's engaged in both. And one thing I'd like to stress is an important aspect of the agency's interpretation in this case is not just the statute. It's also the significance of the contract terms that is at issue. And indeed, you know, one of the things the agency did in its rule was define the terms subrogation and reimbursement and what those significance have for the contract. And I think certainly as to interpreting the contract, the specialized expertise of OPM is squarely in play because OPM, after all, is the entity that is charged with negotiating these contracts with carriers, and indeed OPM has authority to interpret those contracts in other contexts. For example, if a carrier denies a claim, that can be reviewed by OPM to determine whether the carrier's determination was correct. So it's very clear that Congress delegated authority to the agency to interpret the terms of these contracts, and I'd respectfully submit that it's a very small step from that to conclude that Congress also intended to delegate the agency authority to interpret this preemption provision, which does depend in part on the contract on its face. And in that regard, I point the court to the Medtronic case from 1996 in the Supreme Court, which involved a kind of analogous preemption provision under the Federal Food, Drug, and Cosmetic Act, 21 U.S.C. 360K, which likewise made preemption turn in part on requirements that are promulgated by a federal agency. And the Supreme Court held that the agency's interpretation of preemption in that regard was entitled to Chevron deference and it has reaffirmed that holding in subsequent, or that theme at least, in subsequent cases, most recently in the City of Arlington versus FCC case from 2013, which expressly noted that in engaging in notice and comment rulemaking, that agencies have authority to interpret preemption provisions. So I think both things are going on here, Your Honor. The agency's interpretation, and there is some interpretation in the rule. There's discussion of the legislative history. There's discussion of the text of the statute. And indeed, the carrier letter that these interpretations stem from, which was cited in the rule. The carrier letter was issued in 2012 and initially adopted this interpretation, expressly relies on the Supreme Court's interpretation of these terms in the McVeigh case. And so I think that that interpretation is reasonable and is entitled to full Chevron deference and disposes of this case.
I think your time is waning.
It is waning, and
that's not just your time on the clock.
Well, Your Honor, then I'll sit down. Thank you.
Thank you.
May it please the Court. My name is David Abney. I'm representing Mr. Kobold. Mr. Sundin sends his apologies. He's having a knee replacement surgery up in Wyoming. He's pretty much retired. This is his final case, and he wishes he could be here. But when going through this case, I go back time and time again. And in fact, I probably repeated it too many times in my briefing, actually quoting the statute itself. Because every time I was getting into the arguments that were presented by the government and by Aetna, they wandered away from the actual words of the preemption statute. The clause that would be most troubling for me, if you took it out independently, is payments with respect to benefits. The argument that Aetna and the government make is, well, if you get payments from a tortfeasor or from a tortfeasor's insurance company, then that's a payment with respect to benefits. But you really do violence to the language of the preemption statute itself if you take that subclause out and apply it that way. Because the subclause depends on terms of the contract.
We've agreed with that position once, but McVeigh held that there were competing plausible interpretations, and OPM has adopted a different interpretation.
It has.
How are we to hold that OPM's interpretation flies against the plain language of the statute? Much as we may not have adopted it independently.
I believe it's the job of the court to decide what is reasonable as far as an interpretation. Plausible is not the same as reasonable.
Hasn't the U.S. Supreme Court already done that?
No. Plausible.
Plausible. You find great daylight between plausibility and reasonableness.
I find a difference, a significant difference. Plausible is facially valid. You can look at it and say, okay, I can accept this. But reasonable goes further. It has merit to it. It is solid. It is substantive. This is something you can depend on, not just plausible.
That your colleagues and OPM are engaging in frivolous interpretation?
They're engaging in incorrect interpretation. I don't think they're frivolous. They're very serious people, and they're trying to make a serious argument. But I don't think it passes the test of what is reasonable. Because
well, okay, then in your view, what's the difference between the test of what is reasonable and what is most reasonable?
I don't
because if the test is what is most reasonable, that would gut a lot of the law we've just been discussing.
No, and I do not think that Chevron and the many cases that have come after that, actually cases that I believe have tightened Chevron quite a bit, they all are stressing that the interpretation has to be reasonable. McVeigh itself was not really charged with was picking one interpretation or the other. The issue there was the jurisdictional problem.
But you agree that there can be more than one reasonable interpretation?
I think
reasonable doesn't end the inquiry.
I think there can be. I've only come up with one, and I assume that's a lack of imagination on my part. But the interpretation that seems to make most sense to me is to look at the actual words when it says the terms of any contract. And then it has qualifiers to the terms of any contract to relate to the nature, provision, or extent of coverage or benefits or payments with respect to benefits. All of those qualifiers go right back to the initial noun phrase, terms of any contract.
If we had split 2-1 in the first case, I doubt you'd say one of us was being unreasonable. You might disagree.
I would never say that any member of this court is unreasonable, but I would say that an interpretation would be unreasonable, yes. I've identified a reasonable interpretation. The government's interpretation, whatever its plausibility, is not reasonable because it ignores the actual language in the statute.
But you agree that it's plausible? You're just saying it's not reasonable?
I believe it's plausible.
Do you think there's a difference? So at what point, where on the scale does plausibility turn into reasonability?
Well, plausibility deals with a superficial kind of analysis. You glance at it, you say, okay, this maybe would work. I forget the phrase you used for it, for the plausibility of sniff test or something like that, or laugh test. I'm sorry, the laugh test. There comes a point where you're in a discussion with a colleague, you could say, well, that's plausible, but then you have to get down to brass tacks, and you have to decide, well, if you going with the actual words in this statute, what is the reasonable interpretation or a reasonable interpretation? It's not just superficially reasonable, but actually what is a reasonable way to look at this? The only way I've come up with is to go with the language. When it talks about the terms of any contract, and then there's qualifiers to that, you have to look at the actual contract. And there's no term in this contract for subrogation and for reimbursement and subrogation, if you look at the actual terms, that deal with nature, provision, extent of coverage, or benefits. There's no penalty clause in the contract anywhere. If you say, I'm not going to go along with this reimbursement or subrogation nonsense because Arizona state law says I don't have to. And that's been the law of my state for a long time. There's no penalty in this particular contract. Now, in the case they quoted to you, the 10th Circuit case, starts with an H, Helfrich, there was a penalty. They could be denied future benefits. At least that's what the contract provided, which is a pretty draconian sort of thing to say, well, I want to depend upon Arizona anti-subrogation law, and if this were the Helfrich contract, they would be in deep trouble for getting future benefits, but that's not in this contract. And I wonder, even in the Helfrich situation, if that was really a valid kind of thing to be in the contract, because as far as I understand what federal law provides, there is you can only deny benefits for fraud, over insurance, whatever that is, or non-payment of periodic charges. So when they put that into the Helfrich contract, I think they were doing something that was extra legal. You can't do it. There was a phrase that came out at the beginning of my colleague's argument about there was an ability to undo or reduce a prior payment. I'm not sure because it was cut off and it wasn't extended through. But there's nothing in our contract that gives you a penalty if there isn't reimbursement, if there isn't subrogation. There's no penalty in our contract, and that's one reason I think that Arizona state law would apply. One issue that came up very briefly in the discussion was differences between ERISA cases and FEBA cases. I believe your original opinion dealt with that, and there is a distinct difference. The ERISA preemption statute deals with superseding state laws that may now or hereafter relate to any employee benefit plan, and the FEBA preemption statute deals with terms of the contract, which is a highly unusual situation. The constitutionality argument I can discuss with you, but it's not the central feature of our presentation to the court, and not the central feature of our argument at all. We just simply stated it's a plain language interpretation. I don't think a federal agency, even one that's charged with interpreting and applying a statute, gets to say just out of the blue, this is what it means without some kind of analysis, the kind of analysis that this court engaged in the first time around.
But we had to engage in that analysis. It wasn't the analysis wasn't self-evident. When we interpreted the language the way we did, we recognized that there were competing interpretations and had to work our way through it.
Exactly right. But at the end,
so that would seem to suggest then that the language is not so clear that it can't be interpreted in a way contrary to our opinion.
Well, and while I like the original opinion in the case, especially the result,
I'm sure you do.
I think it could have been simpler, because what really, if you look at the preemption statute and just attack it grammatically, what's the subject of the sentence? It's the terms of any contract. What follows that are qualifiers on the terms of any contract. And once you engage in that somewhat simpler analysis, then you don't wander into the thicket of, well, payments with respect to benefits. Well, somebody's paying something here, the tortfeasor's insurance company.
That's the way we interpreted every contract. Business would come to a halt, or contracts would be very long.
Well, I think they'd actually be shorter, and business would flourish because the court would be giving a plain language interpretation to the plain words. And that's really all that's required here, which is not what OPM is doing. OPM is wandering far afield saying, well, there's public policy and the government's, is losing money and this is a bad thing. Well, if it's a bad thing, Congress can fix it. Congress came up with this language, and there's really nothing wrong with the language. If you're worried about, as Congress was at the beginning, well, we don't want states saying this plan has to have certain kinds of benefit, like chiropractic care or other kinds of strange benefits, or it may not provide certain kind of benefits, for instance, abortion services or whatever it might be. Well, this preempts that sort of stuff, but it leaves open for the state law to control what's going to happen with the contract, which has to be an expected consideration from the point of view of Congress. When you're talking about the terms of any contract, you're pulling in state contract law, state to state. And in fact, there's going to be a variation among the FEBA plan providers because each one of their contracts is sort of a separate production. I mean, there may be some huge Aetna providers like Aetna, but each of these contract providers and benefit providers can have a separate contract. So you're going to have contract-to-contract diversity, and you're going to have state-to-state diversity. And if Congress doesn't want that, it can fix it.
But rates are going to be set on the basis of certain assumptions. And the rates, the funding of the program is within OPM's bailiwick, right?
Yes, Your Honor.
So to the extent that OPM makes an assumption based on its interpretation of the law, where are we to go? The differences in the contract don't necessarily address the overall economic model that OPM employs.
Well, it may be a creaky framework, but it's one that Congress set up, and it's only one that Congress can undo. OPM doesn't have the right to say, we would like a better statute, but since we're not going to bother to go to Congress to get a better statute, we're just going to write a regulation that says what we want it to say.
It did go through a notice and comment period, and there didn't seem to be a huge uproar over the interpretation that.
No, I wish I'd have known about the notice and comment period. I would have provided plenty of comments, but it blew right by me. Nobody sent me a letter from OPM saying, Mr. Abney, would you like to comment?
Wouldn't you think that there would be some suggestion or some big controversy if their interpretation was not plausible or just didn't pass whatever test you want to determine for what's reasonable?
I don't know. Sometimes these things in the Federal Register, I mean, I know it's the Federal Register and the whole world's supposed to know about it, but you just get busy, and I never saw it. I never heard of it until, boom, there it is. And I got it, of course, in the strangest way. We had gone to Washington to talk with the Deputy Solicitor General and somebody from the Attorney General's office and a room full of lawyers from OPM to discuss, because the Supreme Court wanted us to go through this process. And then we went away, and May 21 of 2015, this regulation appears, and then the next day we get the OPM brief, we get the Solicitor General's amicus curiae brief, which is signed off on by OPM and a bunch of other people. And it's like, holy smokes. I mean, it was just, I wish they'd have told us they were doing all this at the same time. But I mean, and then, well, anyway, going to Washington was certainly an educational experience for me. But it wasn't very productive as far as justice from my point of view. It was just odd. In any event, Your Honor, I really don't have a more sophisticated argument. I asked the court to take a look at the plain language. As I said, I enjoyed the result of the first time around, but perhaps there's even a simpler way to do the analysis. There is a difference, I believe, between plausible and reasonable.
Is there any authority for that?
Well, I cited English language dictionaries. I don't know if there's any better authority.
But it's not like Chevron has never been the discussion of appellate case law, and this reasonable interpretation concept is fairly well known. Has any authority supported your view that there's a difference between plausibility and reasonableness?
Other than English language, I'm not sure of that. My colleague cited a case that I wasn't familiar with, saying there is the Supreme Court precedent said there was under Chevron if you come up with something that's plausible and not otherwise contradicted by the statutory scheme. But here, I think the statutory scheme contradicts the plausible argument that they are making. I don't know how you...
Meant by my shorthand reference to the laugh test, because if it doesn't contradict the language of the statutory scheme, meaning it doesn't obviously fail the laugh test, and it is plausible, then isn't that sufficient under Chevron?
No, I do not believe Your Honor. Repeatedly, they talk about something being reasonable, which is a higher level. When plausible, the Supreme Court is using these days for civil complaints. And that really is a laugh test. Is it enough that superficially that this makes some sort of sense? But nobody expects a complaint necessarily to be reasonable. It just has to be plausible. It'd be nice if they were reasonable as well as plausible. Of course, every time I draft a complaint, I want them to
Find
be
the
both.
word reasonable in Rule 11, but we don't need to go there right now.
Yes, Your Honor. Anyway, I asked the court to apply the plain language analysis here, and the issue as framed in the opening brief and has been repeatedly presented, especially in the supplemental opening brief, is whether the OPM interpretation is correct or at a minimum reasonable. And that's the issue before the court. Thank you very much for your time. I give my remaining time to the court.
Thank you.
Thank you, Your Honor. Just a few quick points. First, Mr. Kobold agrees that the statutory interpretation OPM adopted is at least plausible, and I did not hear any reason why that interpretation does not cross the threshold into reasonableness. We cited the case Rust v. Sullivan that explains that plausible plus not conflicting with the statutory scheme is sufficient. But most importantly, the Supreme Court made clear in Brand X that it wants the agency to decide the way to resolve these ambiguities, even if a court thinks another view is more reasonable. And Mr. Kobold will be hard-pressed to say that OPM's view is unreasonable, given not just OPM, but the raft of other courts whose decisions we cite in our brief agree with OPM's interpretations and did before OPM came out with that regulation. Interpretation is not just about reading the text in isolation, as this court in the Etheridge case and as the Supreme Court in a raft of cases, including the Gould case, has made clear. It's also about looking to Congress's purpose. Indeed, that's the touchstone in preemption cases. What did Congress intend? And OPM is very well positioned to address that issue here, to know which state laws will interfere with Congress's purpose. And finally, on the contract point, it's not a matter of a penalty that's at issue here. He had an obligation, page A51 of our appendix includes these terms, to repay those benefits, the full cost that we provided to him. For these reasons, we ask you to reverse the Superior Court's judgment.
Thank you. We will take this matter under advisement and issue a ruling in due course. Thank you for your argument.